back to LIRA in Law, broadcasting live from London, England, today, the 18th of July. And as I said earlier, we have lots to do. We have big topics anyway. We definitely have a big topic now today. First of three series, and also lots and lots of questions. So without further ado, let's crack on with it. So ang pag-uusapan po natin ngayon is challenging a spouse refusal. Now, I've been wanting to tackle this topic for a while, but the problem I've always had is there's so many different possibilities, different facts rather, and I couldn't really I didn't know how best to fit it in, and it occurred to me what you want really, is to see it in action. And that's exactly what we're going to do today. So we certainly will deal with pag-usapan nga natin mga batas. Of course, I will make reference to it, and where I can, I'll elaborate nga on the relevant provisions. But titingnan nga natin to, we're going to apply the law to the facts, and we're going to choose, or I've chosen nga, the if you like, the most complex scenario. Okay, and one that is quite common nga, even though it's quite complex. So challenging a spouse refusal. Spouse means, of course, kasal nga kayo. A partner can also mean a partner, unmarried partner. That's also a possibility. But really, focus nga natin ngayon is challenging a spouse refusal. So someone you are married to. Spouse, that's an assumption nga sa akin. Certain assumptions we're making in the beginning, that you are married, you're validly married. Ang pag-uusapan nga natin, the refusal, it can be an in or out-country nga application, but really we're going to focus on in-country applications where they've had refusals nga, so it could be anything. So spouse refusals can be anything like you made an application from abroad, you refused on, say, income, or you make an application in country, you want to switch from something else like work to a spouse, that was refused again for whatever reason. They had concerns about, accommodation, for example. But the most complex situation is where you say, nandito na nga kayo, you made an application, but you don't have a visa anymore, for example, or you have a visa that does not allow switching. So that is actually what we're going to tackle today. So that's why I'm saying this is a big topic. It's quite complex, but bear with me. And if this is your situation, make sure you tune in. Kung meron kayong makilala, mga kaibigan, kamag-anak who find themselves in this rather unfortunate situation, then again, pass this on. Okay? So, tingnan natin scenario. So let me set the scene, as they say. The appellant, dati, ang tawag sa inyo, the applicant, so but because you had refusal, you're looking to appeal, then you are called an appellant, rather than an applicant. Sabihin natin, pumasok nga kayo pumasok siya dito sa UK quite properly, and then became an overstayer. So wala na nga siyang visa, or otherwise TNT. So no visa application was made until recently, and then that application was then refused. Okay, the application was made. So nung applicant pa nga siya, she made an application under the family private life route. Okay, because of the relationship nga with the husband or the wife in the UK who's settled in the United Kingdom. So it's someone British or someone with indefinite leave to remain. Okay? Now, the Home Office looked at the application and then refused the application. Tapos sabi nila, okay, you have a right of appeal, and you can exercise this right of appeal. Tip 1, you have 14 days only. 14 days po, calendar days, not just working days. So, and they're strict with that. If you miss the deadline, then you can still appeal, but you would need to apply for permission to appeal. So don't miss the deadline. Because otherwise it makes an already complex situation even more complex. Now, if you are if you're abroad, you're making an application to the UK and that application was refused, then you have 28 days. Pero kung nandito nga kayo, it's 14 days nga lang, 14 days strict deadline, okay, to appeal. Don't forget to put in your appeal. Now, what would you normally get if you've had a refusal? Okay, and this is in dealing with this scenario, it is a scenario that I come across regularly. So this is a scenario that happens in reality. So what often I see in the Home Office refusal letter, yung actually yung tawag refusal letter, they will likely say, and I'll read to you a section nga, no, from as I say, real case nga. So they do not accept, galing to sa Home Office sulat nila, no? They do not accept, for example, that the appellant met the eligibility relationship requirement because she or indeed he is in breach of immigration law. So, for example, overstayer na nga. Okay, it's just the Home Office's way of saying you're an overstayer. You do not meet the usual conditions. Okay, the usual conditions for spouse would be far easier to actually satisfy. But because wala na nga siyang visa nung nagpasok yung application, different rules are looked at, different provisions will apply, and they are harder. Okay? Now, what will the Home Office look at? No, so they will. Those of you who found yourselves in this unfortunate position, you will remember this reference to what's called EX1 of Appendix FM. I'll just zoom through it. No, so basically they're looking for evidence of what they call insurmountable obstacles. No, that's in accordance with EX2. No? And they often say dito galing din sa Home Office that the appellant and her partner could continue family life in the whatever country, sabihin natin Pilipinas, no? Or that her partner, asawa nga niya, or his partner would be able to support her financially and emotionally from the United Kingdom. So they can pursue a family life elsewhere. Kung nasa Pilipinas nga, galing sa Pilipinas, or anywhere else. No? Now, separately, the Home Office will then say that there are no exceptional circumstances, okay, which would render refusal in breach of what they call Article 8. Article 8 is right to family, private life under the European Court of Human Rights. Or they may say unjustifiably harsh consequences or no unjustifiably harsh consequences for the appellant or family. Do not be overwhelmed by the legal jargon. It just means they don't accept that there are exceptional circumstances that should warrant a grant that wala na kayong visa, no? Now, what's often not in dispute, so you have a long letter of refusal, often going on at least 6 pages nga. And I would say 75%, if not higher, of what's noted are in fact not in dispute. So they accept it, the Home Office. So for example, they may accept, that is the Home Office, otherwise known as respondent in appeal, accept that the relationship is genuine, okay? And they will say so. They accept that, that the relationship is genuine and subsisting. They may also accept that the practical things such as financial support or accommodations, bahay nga, is satisfied. So in the olden days, and of course, if the application was made prior to, so say last year rather than this year, then it would be 18,600 limit rather than the now 29,000 pound limit. So a lot of my appeals, for example, usually, because it takes a long time for the appeal to come through, usually it would be the old limit, which was the 18,600, which was the law that was applicable at the time. Okay. Now, a main issue though, so let me go back into the problems nga, no? Main issue often is the insurmountable obstacles or the exceptional circumstances nga, or unjustifiably harsh circumstances that you need to satisfy under this Appendix FM EX2 or indeed Article 8, the Human Rights Act, no? Now, what do you do? How do you counter that? Okay? Kung yun ang problema, exceptional circumstances ka lang ipakita, o kaya, as I say, unjustifiably harsh, how do you counter that? And that is actually, that can be quite daunting sa mga kliyente ko. I mean, how do we show that? No? How do we prove na it is exceptional? It is, yung kaso namin is warrants grant because it's exceptional and justifiably harsh. Now, one answer to that, the main thing is documents. Kailangan yung ihanda. So it's preparation, but really it is documents. Quality of documents. Another tip po, quality, not quantity. Okay. I've seen appeals prepared where, or indeed applications nga, nagpasok yung kliyente ko, yung abogado nga nila, 20 letters, for example. All the same. No? Iba-iba nga lang taong pumirma. Otherwise, it's exactly the same. They don't like that. And that's not, frankly, helpful to the judge. If you're going to provide nga, documents in support, better to have two good ones, no, different ones, as being and substantially says, kilala namin siya, we know the relationship is genuine, they're devoted to each other, she's looking after the children nga of the spouse, for example. So yun, kilalang-kilala nga kayo. Better to have less and have substantive points to put forward than many and exactly the same, because otherwise they'll just get bored. So really quality of documents. Now, of course, before the appeal here, if it's an oral appeal, especially, you need to submit the documents in advance. You upload it. I won't go through the process now because I want to concentrate on practical things nga. Now, unang-una, practical thing is, and this is often missed out by clients and sometimes nga even representatives, new matters. Okay? So, kung nagpasok kayo ng application, na-refuse nga yung application nyo, tapos, kailangan yung dagdagan. Hindi nga lang yung to support your case before, so up-to-date documents, for example, up-to-date bank statements, hindi yon, but new matter. So sabihin natin, in the interim, your spouse became sick, no? Not just cold, no, but actually illness, no, condition nga, or nanganak kayo. So all those things may be considered by the Home Office as new matters. Now, why is that important? It's important because there's case law to say the Home Office need to agree for new matters to be brought, to be discussed at court, no? to be part of the proceedings. If they say no to the new matter being brought up at court, then the judge does not even have the possibility of saying no. Home Office, they have to deal with this. So where you have new matters, tip ko ito. If you know, you would normally know it's a new matter because you haven't submitted it in advance. Write to the Home Office. They're going to review your case anyway before the hearing. They have to do that as part of the process. But write to them and say to them, look, this is a new matter. These are documents in support of my new matter. Can you please confirm that this will be dealt with at court? Now, importante po yun dahil nga otherwise you're precluded from dealing with it at court. And if it's important, obviously you want it dealt with. Or the matter is then adjourned. So the judge will say, well, I can't hear it. They're saying no to the new matter. So the Home Office will need to look at it, they need to review it afresh, and then we have a hearing. And if you have solicitors and you have barristers, that costs money, an adjournment. So tell them in advance. Okay. It could be that you can say, look, if you don't hear from the Home Office, it could be that you then write to the tribunal. Another tip, in advance of the final hearing, sabihin nyo, there's a new matter. Can we have a small hearing, a case management hearing, ang tawag nga, when the judge will consider whether the new information, the new matter, because it could be that the judge says, well, for the new matter, you need not necessarily bank statements, but medical report, all that, you see. But more importantly, for the Home Office to accept that it's a new matter, that it will be dealt with. So it's quite, I'm always surprised at how it's missed out, even by solicitors also. So beware new matters, okay? Now, witness statements. For goodness sake, prepare good witness statements. There's no point being just melodramatic about it. You'll just bore them. The judge will just, you will just annoy the judge. They want to, of course you can say, how you feel, but it should not be 90% how you feel. You need to back it up also. So always prepare a statement for you and your partner, no, on a spouse a spouse appeal. Importante po yun. So, and you need to be factual nga and back it up. So if you're saying that you're earning, no, 29,000 pounds or 18,600 pounds, which was the old limit nga, provide your pay slips, provide your bank statements. Dahil kailangan makita, hindi nga lang pay slips. They want to see that money is actually going into your account. There has to be that connection. Okay, so but always prepare a statement. The reason being, they always go back to it. When you give evidence at court, you give oral evidence. The judge will normally not ask you everything. They can't, no. Otherwise, the hearing will last a week. They can't ask always. So, ang una nilang titingnan is yung statement mo. Are there points that they want to raise? Or later on, you know, if the judge is wants to be reminded about certain things na sinabi nyo, the judge will always go back na to your statement. So I cannot stress enough how important statements are. And I do mean statements, no? Hindi nga lang sulat. And that should also apply to witnesses, even if they're potentially not coming to give evidence, because it's more formal. No? Statements should start with, you know, I, and ang pangalan nyo, address nyo nga, and make the statement knowing the same to be true, and then explain who are you. No? Don't forget also, make sure that you have evidence of your ID. If you're the spouse nga, make sure you have your passport with you in case the judge wants to see the original passport. You know? And if it's a remote hearing, you can always, you know, show it to the camera. Okay, but it's important you have ID. If you have witnesses, again, they must bring their ID. Again, a practical tip, because they may not accept, you know, that your witness is who they say they are. And how do you prove that? If they have a driving license with their photo nga, and also and passports. You know, passports is the easiest thing. So you have that along with the witness statements nga. Okay. Now, apart from witness statements, what else can you put forward? Country-specific reports. Okay. Now, if you go on the Home Office website, meron kayong makikita country reports. No? So there may be, not all countries would have a country report, but there may be, I know there are country reports, say for the Philippines nga, it will say there, you know, what's the health system like, for example, information about divorce or the lack of divorce. So those things you can download and you can include that also in your bundle. Importante nga yun, because that again is something that the judge will go back to. So if you're saying may sakit ang asawa ko, hindi kami pwedeng bumalik nga sa Pilipinas, dahil sa Pilipinas is not going to be entitled to assistance. Why do you say that? How do you back it up? And again, the country-specific report may well help with that. Now, alongside that, they also have Home Office policy documents. Iba po yun. Again, that's on the Home Office website. So the Home Office policy documents, for example, would say if a country is deemed to be dangerous, you know? If you are advised not actually to go to that country. And that, again, is helpful. You know? And as I say, what's the health system like? Now, again, back this up. It could be na kailangan yung report. You know? If you need a report, then of course you need to instruct someone who is an expert in that field. So kung nasa Pilipinas nga yung, so kung galing kayo sa Pilipinas and you want an expert to report on the health system there, then you probably need to instruct someone who actually is very familiar with the health system nga in the Philippines. We'll talk about PhilHealth and entitlement nga, you know, insurance, how costly it is, all of those, no? So again, back it up. Kung sabi ng Home Office is that the family can help you out with accommodation, no? Marami kayong pamilya sa atin. Again, try and counter that with statements, no? So kung sabi ba nila, o apat ang anak nyo, o tatlong anak nyo, no? Who can help you out? Where do they live? You know? If they live in a place that's not suitable nga for you, o kaya sa kanila din, no? Take photos, no? Prepare a statement sa kanila nga din, no? To say dito nga sila nakatira, their asawa nga nila nandun din, mga anak nila 3, 4, 5, no? There's just no no space nga for you. So again, counter it. Tingnan nyo maigi yung refusal. What are they saying? And then prepare your case accordingly. No. Another thing also that can be helpful, again, no practical tip nga is how long is it taking for applications to be dealt with? Okay, I know in the Philippines, if you have a background, actually even if you don't have a background, you're looking at least 6 months, you know, for oftentimes for entry clearance applications. It could be longer if there's a background. In some cases, well, if it's not a question of a background as in a failed appeal, then it could be that you can make an application on a priority service. But if you have an appeal, that means you've had a refusal, that means you have immigration background, you can't make use of the priority service. You know? So you're looking at 6 months minimum, likely longer than that. Is that going to impact on your family life? So kung may sakit yung asawa nyo, nandito siya, wala namang mag-aalaga, how's the care going to be provided? You know? Because 6 months can be crucial to someone quite unwell. Certainly 1 year can make a difference, you know, life and death type thing. So again, it's important nga na pakita nyo nga din yon. You know, what is the, you can see that also on the Home Office website. Makikita nyo doon, they have time estimates, you know, how long an application will take. And I can tell you this now, you know, it's if they say 3 months, you can easily double that. You know, if they, especially nga kung meron kayong background. Now, also, again, this is a tip, no? Would you satisfy, you know, the Home Office, the immigration rules, if it were not for the immigration background that you have, no? So kung hindi nga kayo overstay, would you otherwise satisfy it? So the immigration rules provide for spouse applications nga, income must be 18,600 in the past, now 29,000. There must be accommodation. You must be able to speak English. You need to be able to show a genuine subsisting relationship. So all those things, do you tick those boxes? Because if you do, and there are exceptional circumstances, case law say that it should not be an automatic thing that you then refuse. Okay, so if you satisfy the immigration rules, say that also. No? Deal with it also in your statement. Ang income ng asawa ko ito. I've done the A1 English language test, and if you haven't, you should. No, because otherwise it's difficult to also show that you can speak, you can satisfy, or you do satisfy the level of English na kailangan nila, no? And income, as I say, provide payslips, provide bank statements, contract of employment. So all those things, no, need to be provided. Beware, again, I mean, a little bit of law, but it's a practical issue, no? If you're faced with this situation, kailangan yung tignan Section 117B, no? 4B actually. So it says there, kung wala kayong visa and your relationship started nung wala na nga kayong visa, that section says that little weight must be accorded to a relationship with a qualifying partner, no, which was established at the time when the appellant was in the country unlawfully. So kung overstayer nga kayo and you started your relationship when you were an overstayer, Section 117B says little weight. But it does not mean no weight at all, okay? It must still be accorded some weight. So it doesn't mean that it counts for nothing. And again, Article 8, as I say, ang kaso nyo, removal will be disproportionate and will result nga in unjustifiably harsh consequences if it does not lead nga to a grant of visa. So all those things, no, you need to deal with in documents. So as I say, how do you, oftentimes by my client go, how do we prove that? No, how do we deal with this exceptional circumstance and the undue hardship, the insurmountable obstacles? How do we counter that? Answer is documents and preparation. But it really just boils down to documents. And make sure that you in practical tips that you you're not late for your hearing. Okay, lots of people are the cases are really all listed at 10 o'clock. Hindi nyo nga lang alam who's gonna get dealt with first. So you should not be late. Nevertheless, make sure you check a week before that kung kailangan yung interpreter, that you have an interpreter nga ready, no? And that you tick the relevant box, no, on the appeal form. Especially important nga, I mean, even in remote hearings, but certainly in in-person hearings nga, dress smartly, okay? Because it's of course, you will not lose your case just because you're wearing jeans, but I do think it sets the tone. No? Make sure nga that you are that you're properly attired. No? That you're showing the court the respect, and it should be the case because the court should be respected. No? So yung nga, again, it's a question of showing the court and the judge that you're taking this seriously, because the people too, no? They form opinions, and they look at you and they ask you questions also directly. So you want to you want to get them on, if you like, on your side. But I mean, they are independent, but you don't want to necessarily make a bad impression, no. So again, just it's smart casual. You have to go in. You don't. I'm not saying go into it in tux or but 3-piece suit. It doesn't have to be that way. But just properly attired. No. So all that preparation hopefully will then mean that you will successfully challenge and win. No. Your spouse refusal. And if you do, what will then happen is the judge normally will not give the decision there and then. They will normally say, okay, I'll make I'll provide you with my decision in writing. It may take them 2 weeks to do so. I'm astonished at the moment that it's taking far less than 2 weeks. A couple of cases that I had recently took 1 day. Well, a weekend actually. Had the hearing, had a couple of hearings on a Friday. I got the decision on the Monday. Astonishing. So it can be as quick as that. And if you win it and they don't challenge, that is the Home Office. They have 14 days to challenge if they want to challenge. And you too have 14 days to challenge if you lose it. It just means that you can then, they will then simply grant you a visa. It could be that you need to do your biometric again, but then you should have a visa. So look, kung nangyari nga ito sa inyo, you've made an application, you had a refusal, do not be disheartened, really. That's the starting point, no? You can potentially appeal it, and if you do appeal it, it could be that you win it, no? But to win it, you need to prepare your case well. And how do you do that? What's the starting point? Documents. Okay? I cannot emphasize that enough. You need to be prepared now with your documents and the other practical things. As I say, kailangan yung interpreter, by all means get an interpreter. Libre nga, no interpreter, okay? That's something provided nga by the court. And just make sure that everything is uploaded. Bear in mind, sabi ko nga kanina, new matters, no? Now, I hope that was helpful to you. And as I say, I tried and I will try, certainly in this series nga natin, the 3-part series nga natin, to be focusing on practical stuff, because I think that's really what you want to hear from me about. Now, okay, so I think we're going to go into our Batian section, which I missed last week. I know, I mean, I always say this because it's so true. It's my favorite part of the show, Bati. And hopefully you didn't forget me just because I wasn't there.